itself was procedurally defective. Furthermore, we subsequently filed a separate application to have portions of that hearing, as well as others, declared null and void. And accordingly, it's hard to imagine how we could have objected to the quality of the proceedings in a more comprehensive manner. If we have been unclear, let me now state definitively for the record that we strongly object to the quality of the adversarial hearing, and in particular to the OCIJ's decision to proceed in the absence of counsel. Secondly, I will address the OCP's substantive argument that the hearing was fundamentally fair. In support of its position that the waiver of our client was informed, the OCP states, and I quote, "The charged person understood the consequences of the waiver of the right to legal counsel." This remark, however, is based on the incorrect assumption that our client was provided advice as to his right to legal assistance by a representative of the Defense Support Section shortly before the hearings commenced. And the OCP the OCP notes that it is difficult to imagine, I quote, that the advice given to this charged person was not comprehensive. Now this is incorrect, Mr. President, members of this court, this chamber. The DSS is prohibited from dispensing legal advice to accused persons. We have reviewed the notes of DSS meetings with our client on 19 September 2007, and we can confirm that, contrary to the OCP's assumptions, not only was the advice very limited, in keeping with the DSS unfortunately limited mandate, but our client quite emphatically expressed his desire to have the hearing postponed so that he could regain his composure after what had already been a trying day for a man of his age and condition. I will take 4 literal quotes from these notes from the staff of DSS. Our client at that meeting said, "I would like to rest before eating. I would need to rest first. I am not fit to take part in a hearing. Please persuade them to give me time to rest. I am exhausted." Of course, I am well aware that you are not in the possession of these notes, and I invite you to look at a copy of these notes. However, these are confidential notes, so we must find some way to resolve the issue of lawyer-client's privilege. In support of its position that our client's apparent waiver of his right to counsel was voluntary, OCP also notes that he would have been completely familiar with legal and administrative processes, including what such processes represent and how they work, due to his previous experience as the leader of the nation, quote unquote. First of all, the proposition that our client led the nation is disputable. Indeed, it is one of the questions for judicial determination in these proceedings, which, for the reasons just explained, cannot now be taken for granted. Moreover, as noted by the Cambodian Human Rights Action Committee, as I said, amicus curiae in these appeal proceedings, the right to counsel is a relatively new concept in Cambodian law. And I would like again to quote this organization because it's very insightful. I quote, "The right to be represented by counsel was unheard of during the time of the Khmer Rouge and even during the subsequent Vietnamese occupation. Today, it remains in its infancy. In fact, under the Khmer Rouge regime, merely being questioned by authority figures would have been a threatening and coercive experience. Thus," I'm still quoting the Cambodian Human Rights Action Committee, "thus, in the legal and cultural reality of Cambodia, a decision to proceed with questioning in the absence of a lawyer may be less a voluntary waiver than an instinctual reaction to authority and to a legal proceeding that one has never been before encountered and does not understand. Under the circumstances," still quoting Cambodian Human Rights Action Committee, "under the circumstances it would hardly be surprising if Mr. Nuon did not believe he had a real choice, but rather felt coerced, giving the apparent contradiction of the co-investigating judge's words and actions, giving his poor health, the potentially intimidating authority of the co-investigating judges, and the legal culture of Cambodia. It is conceivable that Mr. Nuon did not believe that he would actually be allowed to avail himself of his right to counsel, and that he felt coerced into waiving it." End of quote. It cannot be credibly disputed that the OCIJ's acceptance of our client's alleged waiver, without so much as a cursory warning of its consequences, is a practice foreign to criminal law systems. In most domestic and all international systems, procedures and practices are in place to specifically ensure that the waiver of a right, as fundamental as that of the right to counsel, is only done voluntarily, knowingly, and unequivocally. For example, in the case of Slobodan Milosevic, before the trial chamber of the ICTY, the issue of the accused's right to self-representation was resolved only after comprehensive legal submission by the accused himself, the prosecution and various esteemed amici curiae. It is fair to say that the trial chamber of the ICTY itself went to considerable lengths in attempting to convince Mr. Milosevic to accept at least the imposition of standby counsel in the interest of a fair trial. Ultimately, Mr. President, members of the pre-trial chamber, after proper deliberation and publication of a reasoned decision, his personal and fundamental right to represent himself was upheld. It was indeed a painstaking process that required a searching analysis of the law and facts, and no doubt consumed valuable judicial time. However, those concerned with the vindication of fair trial rights would consider this time well spent. Indeed, such extensive inquiry is what the law at times requires. Of course, our client enjoys the fundamental right of self-defense. However, the OCIJ, like all judicial bodies of the ECCC, has an equally important obligation to ensure that the proceedings are conducted fairly and impartially. Accepting our client's apparent waiver without question and then seeking to justify it with nothing more than a reference to Article 14 of the ICCPR is, in our opinion, not appropriate. The ICJ's decision thus begs the question, as a matter of prudence and good practice, what possible advantage was gained by moving forward with such speed and in the absence of a lawyer? Pursuant to the administrative regulations of this court, as I said earlier, the defense support section is expressly forbidden from dispensing legal advice to accused persons. Furthermore, there is no provision for the availability of duty counsel to assist those without legal representation. So the sense of urgency was unfounded. And Rule 51, paragraph 3 explicitly allows for a suspect to be held pursuant to an ECCC arrest warrant for up to 72 hours. So, why the hearing was not postponed for less than 24 hours to ensure the presence of Mrs. Sonarun is therefore not explicable. Perhaps more informative in this regard is the OCIJ's conduct in the wake of the submissions of this very appeal. Mr. Yang Sari and Mrs. Yang Tirit were both arrested on 12 November 2007. And they were brought before the OCIJ for their initial appearances on the same day. Both were represented at those appearances by their chosen counsel, and in both cases, after advising the charged persons of their rights, the OCIJ adjourned the proceedings, expressly stating, and I quote, "In order to respect defense rights, we will adjourn the adversarial hearing and place you in police custody." And the adversarial hearing took place, the hearings took place 2 days later. Same goes for Mr. Chea Sampan. He was arrested on 19th November 2007 and brought before the OCIJ for his initial appearance on the same day. Like Mr. and Mrs. Yang, Mr. Chea Sampan was represented by his chosen counsel. Mr. Sampan elected to proceed with his adversarial hearing on the same day, but only after being specifically advised that he could have postponed the hearing for 48 hours. Therefore, in the case of the three charged persons arrested after our client, greater deference for defense rights was shown by the OCIJ. And the implication is that the procedure employed with respect to our client was not appropriate and required a change. The prejudice, that is the practical effect to our client is that several statements now form part of the record and may be used against him. And this consequence was not explained to him by the OCIJ in advance of his adversarial hearing, as it was presumably explained to the other 4 detainees by their lawyers. So what we are saying is that our client, therefore, is unique in the sense of being the only charged person at this court to have undergone a hearing without the benefit of legal counsel. Finally, Mr. President, honourable members of the pretrial chamber, I shall address the central question of our appeal, and that is whether or not the requirements for provisional detention, as set forth in Rule 63, have been and continue to be met. Allow me to first briefly outline a few sections of the rule itself. Rule 63, paragraph 1 states that the co-investigating judges may order the provisional detention of a charged person after an adversarial hearing. The use of the English word may as opposed to the word shall in this first sentence of the rule is important and merits a brief explanation. According to this rule, the co-investigating judges are not required to place a charged person in provisional detention. Such a system of automatic or mandatory pretrial detention would of course amount to a violation of universally accepted legal norms. I think that much is indisputable. As Rule 63, paragraph 1 further states, if provisional detention is not ordered, the charged person shall be released. Now the OCP has stated, and I quote, each case is to be judged on its own merits. However, in practice, provisional release has been rarely granted before other international or internationalized courts. End of quote. In our opinion, this is not entirely accurate, as the ICTY has granted provisional release in various cases. Now, the OCIJ's discretion is not without limits. In fact, it is circumscribed by Rule 63, paragraph 3, which provides that provisional detention is appropriate only where certain conditions are met. First of all, according to Rule 63, paragraph 3a, there must be a well-founded reason to believe that the charged person may have committed the crime or crimes specified in the introductory or supplementary submissions. For purposes of today's hearing, we assume but do not concede that this first prong of the Rule 63, paragraph 3 test is satisfied. This alone, however, is not sufficient to impose provision detention, which is, after all, a serious deprivation of liberty of one presumed to be innocent at this stage of the proceedings. Rule 63(3)b further requires the OCIJ to consider provisional detention to be a necessary measure to 1. Prevent the charged person from exerting pressure on any witnesses or victims, or prevent collusion between the charged person and accomplices of crimes falling within the jurisdiction of the ECC. 2. Preserve evidence or prevent the destruction of any evidence. 3. Ensure the presence of the charged person during the proceedings. 4. Protect the security of the charged person. And 5. Preserve public order. We must, of course, give effect to the plain meaning of statutes and rules. However, as is often the case in law, we must also look beyond the text of any particular rule to the practice and jurisprudence in order to see how best, that is, how most fairly, to interpret and apply it. As noted in our brief, the jurisprudence of the European Court of Human Rights and the other international tribunals is instructive in this regard. And as argued in our brief, none of these additional 5 criteria is satisfied in this case. A finding of any one of them must be based upon established facts vis-à-vis the charged person, and not only speculation or unsubstantiated general concerns. Abstract perceptions of the prevailing situation are not a proper foundation upon which to justify an order for provisional detention. Having said all that, let me now address the various additional grounds relied upon by the OCIJ. First of all, the OCIJ has held that because Nuon Chea faces a maximum sentence of life imprisonment if convicted, it is feared that regardless of his protestation to the contrary, he may be tempted to flee legal process. The OCP suggests that this finding is substantiated by the fact that Nuon Chea's family's home is situated very close to the Thai border, and by the further allegation that he possesses a valid passport. It must be reiterated that the risk of flight may not be assessed solely on the basis of the gravity of the offence. Such a finding is contrary to the relevant human rights law. And despite having had many chances to do so already, our client has no intention of fleeing the jurisdiction of this tribunal. Indeed, as supported by the OCP's own evidence, he has publicly and consistently stated his willingness, indeed eagerness, to participate in these proceedings since 1999. To the BBC in 2004, our client said he would not try to avoid assuming moral responsibility for what happened during the period of the Khmer Rouge rule, and is ready to stage his own defense himself before the court. 14 June 2007, to Al Jazeera. As the international court builds its case against him, Nuon Chea says he is fully prepared to face his accusers. And to the Cambodia Daily, I quote, Nuon Chea said he has been preparing himself for a trial for many years. I already have informed my children about the trial. It is nothing I am worried about. I am firm at this point, he said. Don't worry, he added, I will go to court when they need me. This is the Cambodia Daily. A single document on the case file indicates that our client may have been in possession of a passport in 1999. However, this is inaccurate and presumably could have been verified by inquiry to the relevant government authority. In any event, no passport was discovered at his home at the time of the arrest, and he has already affirmed that he does not in fact have one. Assuming for purposes of argument that our client did wish to abscond, his age, fragile state of health, and lack of financial resources would make it virtually impossible for him to do so. And now that proceedings against him have begun in earnest, the Cambodian and ECCC authorities clearly have the will and material ability to ensure that his movement within the country is sufficiently monitored and restricted. And again, the submissions of the amicus curiae are instructive in this respect. Let me quote them again, Mr. President. They say the ECC must present evidence to indicate that Mr. Nuon has the intention to flee and to not present himself to the court if released on bail. CHRAC, the name of the organization, is unaware of the existence of this evidence and thus cannot make a determinative statement on this matter. Now, in its decision on the Duke's appeal, this chamber noted that for 20 years, from 1979 until 1999, Duke disappeared from public view and took different measures to conceal his past and avoid being recognized as Duke. Our client, by contrast, has lived in the public eye since late 1998 and has never made attempts to conceal his past or deny his identity. And perhaps most telling in this regard are his own words, and I quote, "If I wanted to flee, I would have done it a long time ago. Where would I go? I could flee in just one step to the Thai border. It is near my house." The OCIJ has held that given Nuon Chea's specific hierarchical position, number 2 in the regime, it may be feared that if he were to remain at liberty, he might attempt and would be in a position to pressure witnesses and victims, especially those who were under his authority. Now, the OCP suggests that this finding is substantiated by the allegation that our client has previously criticized Duke for not destroying evidence, as well as by Nuon Chea's alleged position of power and influence in Pailin, where, and I quote, "a culture of impunity for former Khmer Rouge leaders prevails and potential witnesses live in fear." It must first of all, Mr. President, members of the Court, be reiterated that the fact that the charged person may continue to possess some influence is not an automatic indication that he will exercise it unlawfully. Further, as also noted in our brief, the detention order is lacking in factual support and in essence amounts to a statement of conjecture, because it says it may be feared he might attempt and would be in a position to pressure witnesses and victims. And the OCP places great emphasis on a comment allegedly made by our client to Duke in 1983 regarding the burning of certain unidentified materials. Now, assuming for purposes of this hearing, but not conceding, that he actually made such a comment some 25 years ago, the most that can be gleaned from the file is that he may have burned some unidentified papers prior to 93, nothing more. The suggestion, as made by the OCP, that our client in fact deliberately destroyed incriminating evidence with a view to preventing its later use in some hypothetical future criminal proceedings is of course not plausible. The reality is that the OCP has produced no evidence whatsoever that our client has ever destroyed or encouraged the destruction of a single document relevant to these proceedings, nor that, if Duke's comments are to be believed, he has destroyed any documents at all after 1983. Furthermore, there is simply no evidence on the record that Mr. Nuon has had appropriate contact with a single witness, victim, or third person. Yet again, the amicus curiae submissions are very enlightening, and again, I would like to quote them. CHRAC is not aware of any specific evidence regarding threats made by Mr. Nuon against victims or witnesses. Mr. President, members of this course, neither are we, and neither, it seems, is either the OCP or the OCIJ. I come to the last point, the preservation of public order and the safety of the charged person. Now, the OCIJ has held that the alleged crimes still profoundly disrupt public order to such a degree that it is not excessive to conclude that the release of the charged persons risk provoking, in the fragile context of today's Cambodian society, protests of indignation, I'm quoting, which could lead to a violence and imperil the very safety of the charged person. Given that the situation is clearly no longer seen in the same way since the official prosecution against him has commenced, the argument of the OCP. Now, with respect to the public order aspect, the OCP suggests that this finding is justified on account of resurfacing anxieties and their attendant negative social consequences, and because release would be seen as a major setback by the public. As to our client's personal safety, the OCP submits that the situation has changed because the official prosecution has started. That members of the public at Duke's hearing had trouble restraining themselves from spontaneous acts of violence, and that provisional release would be seen as contrary to the end of impunity and spark attempts to harm Nuon Chea. Now, an abstract threat to the public order, based on the gravity of the offense alone, cannot be used to anticipate a custodial sentence. Rather, in accordance with the international legal principle of proportionality, the public order justification, like the others, must be invoked only where it is justified by precise facts, and where it is the only means of quelling an actual disturbance. Now, if the position of the OCIJ and the OCP is to be believed, this country is poised to erupt at the slightest provocation. In our view, this is simply not the case. And the OCP's reference to the anti-Thai riots in 2003 do not support this theory. The ICTY, for example, releases accused persons prior to trial pursuant to sufficient guarantees of attendance, despite the gravity of crimes charged or positions held by the accused. Now, the suggestion that Cambodian society is too fragile to comprehend and respond appropriately to the provisional release of an accused person presumes that nothing less than guilty verdicts and severe punishment will keep the public from engaging in violence. Now, of course, the defense acknowledges this Chamber's concern, expressed in the Duke appeal decision, that large portions of the Cambodian population are still suffering in some measure from the events which took place from 1975 to 1979. However, it must be emphasized that reliance on public order concerns as a justification for provisional detention must be linked in some particular manner to the charged person himself. Otherwise, the court will be seen to sanction a regime of de facto mandatory detention. And that, of course, is not permissible. Our client has been peacefully reintegrated into Cambodian society for almost 10 years, during which time there have been no acts of violence in protest of his liberty or attempted acts of revenge against him. And the fact that several other well-known ECCC targets continue to live freely and peacefully in Cambodia does not appear to have caused any disturbances to the public order either. And it seems that the OCP freely admits that the concern is speculative. I quote them: "It would be nearly impossible for the ECCC to predict with any certainty whether the release of a person charged with the commission of international crimes inevitably would cause public unrest in a country of millions." We, the defense, Mr. Nuon, Chea, we fail to appreciate why that situation should be seen to have dramatically altered now that our client has been charged. If, Mr. President, members of this chamber, if this chamber is diligent in explaining the presumption of innocence and imposing conditions to ensure Nuon Chea's attendance, why should we expect an unruly mob to descend upon him if released? If the OCP, the OCIJ, or indeed this chamber has credible evidence that public order will actually be disturbed, by all means place it on the record and we will be satisfied that provisional detention is warranted. With regard to the personal safety of our client, he actually has said it best himself at the adversarial hearing. He said, "If anyone had wanted to kill me, they could have done so already." These subjective views are, of course, bolstered by the objective submissions of the amicus curiae, where it is said that the CHRAC does not have access to specific evidence indicating a threat to Mr. Nuon's personal safety. Now, this chamber has previously emphasized the fact that Duke himself complained about his safety to a journalist called Nate Thayer in 1999. It must be noted that our client has expressed no such anxiety for the very simple reason that he does not live in fear. This chamber has also noted Amnesty International apprehension that Duke may be killed to stop him testifying against others involved in crimes against humanity. And again, there is no such concern with respect to our client, who has no intention of testifying against his comrades. Neither the OCP nor the OCIJ have pointed to any specific threats to our client's personal safety. And it is our submission that such threats simply do not exist. Therefore, Mr. President, honourable members of this pre-trial chamber, we request this chamber to decide that this appeal is admissible and to order the release of Nuon Chea. Thank you.
Before we take a recess, I would like the defense to submit a written submission to the greffier. I would like to announce the recess for 15 minutes.